things like books, plays, paintings, and photographs. What can't be protected? Things like ideas, facts, short phrases, or slogans. Now, just a side note here, at least with some of these, there are other types of legal protection other than copyright. So, for instance, short phrases or slogans may have trademark protection, but for copyright purposes, these things can't be protected. So, who owns a copyright? Generally, the author who created the work, like the writer, the painter, or the photographer, is the owner and has copyright protection automatically from the moment the original work is fixed. But there are exceptions. So, work made for hire. When a work is made for hire, the author is not the person who actually created the work. Instead, it's the party that hired the individual. That's who is considered the author and copyright owner of the work. So there are two situations in which a work may be a made for hire. The first is when the work is created by an employee within the course and scope of his or her employment. The second is when an individual and the hiring party enter into a written agreement signed by both parties that the work is to be considered a work made for hire, and that work is specially ordered or commissioned for use as one of 9 categories. And those categories are a contribution to a collective work, like an encyclopedia, a part of a motion picture or other audiovisual work, a translation, a supplementary work, I'll get to what that is in a second, a compilation like an MOS compilation, an instructional text, a test, answer material for the test, or an atlas. So again, a work made for hire can only be a work made for hire in 2 situations. And again, the relevance of a work made for hire is that the person who actually created the work is not the author and owner. In the employee example, it would be the employer. In an independent contractor example, it would be the person who hired the contractor. But remember, with an independent contractor situation, it is only for those 9 specific categories. I mentioned supplementary work. I'll just go through that briefly. What that means is basically a work prepared secondary to another work for the purpose of explaining or introducing. So like something like a foreword or a bibliography or an index. So kind of stepping back again, this means that if you hire an independent contractor to create something, and it's not within one of those 9 categories that I just went through, then it can't be a work made for hire, and the independent contractor will remain the author of the work. Now, just a side note to mention here, you'll often see agreements that attempt to make something a work made for hire that don't actually fall in any of those 9 categories. And why will you see this sometimes? Well, it's a belt and suspenders approach. I'm going to throw everything at the wall and I'm going to see what sticks. That's why you'll frequently see what's called assignment language alongside work made for hire agreements, and we'll get to assignment in a second. So next up, what rights does a copyright owner have? Well, copyright owners own certain exclusive rights, like the right to reproduce the work, the right to distribute the work, to display the work, the right to make derivative works, which basically is to create something new from an original work. Those are not all of the exclusive rights, but those are some of them. And so the next question is, can I grant or share rights with others? And the answer is yes. A copyright owner can grant or share certain rights with another through what's called an assignment or a license agreement. And first off, I'm going to talk about assignment. So an assignment is when a copyright owner transfers ownership of the copyright to another. To be effective under the law, an assignment has to be in writing and has to be signed by the author. So this is similar, think a sale of a home. It's similar to a sale of a home. When you are selling your home, you are transferring your ownership interest in that property to another person. Same deal with an assignment. Switching gears now to a license. So when a license or when a copyright owner only transfers some of his or her rights for a limited period of time or a limited purpose, that can be considered a license. With a license, you transfer your rights in the copyright to another person, but you actually retain ownership of the copyright. So in the previous example and assignment, we talked about how that's similar to a sale. With a license, think a lease of the home. You're retaining ownership, but you're leasing the property out for use. Now, license agreements can be exclusive or non-exclusive for a limited period of time or for a perpetual period of time, for a limited geographic area or worldwide. Now, a license agreement, I think it's important to note, a license agreement may not always come in a form of a traditional agreement, you know, a stack of papers with a signature on it. It could be through a website's term of use or through a pop-up agreement. It doesn't just have to be what you traditionally think of as an agreement. Now, on the screen is an example of a pretty basic license agreement or license grant. And I want to go over some of the terms there because at some point you may run into something like this. Of course, this is just intended to be general information. It's not a substitute for legal advice, but at least this can give you a somewhat better idea of what these terms may mean. So let me get a little bit closer here so that's easier to read. So the license grant language says, subject to the terms and conditions of this agreement, licensor hereby grants to licensee. Okay, let's start with that. So the licensor is the copyright owner, and the licensee is the person being granted the rights. So let's think about a photographer and a broker. The photographer takes a picture, is going to license that photograph to the broker. So in that case, the photographer is the licensor, the broker is the licensee. Licensor hereby grants to licensee a non-exclusive. What does that mean? Well, exclusive, non-exclusive, that deals with who can the copyright owner license to for that particular purpose. Just one, even to the exclusion of the owner, that's exclusive. So if you're only licensing to one, that's exclusive. To many, that's non-exclusive. The next term there is non-transferable. What is that talking about? Well, that's talking about, can the licensee assign his or her rights to another? If the answer is yes, it's transferable. If the answer is no, it's non-transferable. Worldwide, that is talking about where can the licensee use the work. Everywhere, that's worldwide, or only in a certain area, like a state or a country, that would be more limited. Perpetual versus limited. How long can the licensee use the work? Forever? Perpetual. Or for a specific term, that would be limited. And then finally, royalty-free. Does the licensee need to pay royalties or fees for each use or copy? So if it's royalty-free, the answer is no. There's a couple other terms that you might see that I want to just throw in here very briefly. You may see the term sublicense or sublicense through multiple tiers. What is that talking about? That's talking about, can the licensee share his or her rights? If yes, it's sublicensable. If no, it's not. For those of you familiar with leasing, think a sublease, similar to a sublease. And that term multiple tiers that I just went through, multiple tiers refers to how far that sublicensing can go. Can the sublicensor sublicense? So that can get a little confusing. But basically, can the licensee share his or her rights? The other term I'll just mention is you might see revocable or irrevocable. Basically, can the copyright owner revoke or terminate the license? If yes, it's revocable. If no, it's irrevocable. So generally, if you're a copyright owner, you're going to want a more limited license, more restrictions. Whereas if you are a licensee, you're going to want more ability, a broader license, less restriction. Now I'll just go through the rest of this license grant. So licensor hereby grants to licensee this license to reproduce, display, and distribute. Those are some of those exclusive rights that we just talked about. And then the purpose is, let's say, for marketing the licensee's service. So that's, again, an example of a pretty basic grant, but if you run across that, you may have a somewhat better idea of what those terms may mean. So how can I protect my copyrights? So I've got some content I want to protect. How do I do that? Well, there are really three ways you can help protect your copyright. The main one is registration. While timely copyright registration with the U.S. Copyright Office isn't necessary to establish your copyright, remember we talked about earlier, you have copyright protection from the moment the work is created. There are some very important benefits to registration. The first is by registering your work with the United States Copyright Office, you are creating a public record of ownership. You are letting the whole world know that you own that copyright. The second main benefit of registration is suing for infringement. So a copyright infringement suit cannot even be filed without a copyright registration. So while you might own the copyright at the work's creation, you might have that protection even at the work's creation without registration, you can't sue for infringement without registering the work. The fourth benefit of registration is that registration can establish prima facie evidence, basically a presumption of the validity of the copyright, that the copyright is valid. If that registration is made before or within 5 years of publication of your work. So this can be really helpful if you do decide to go to court to sue for infringement. You get that presumption that the copyright is valid. And the fourth benefit of registration, which we'll get into in a moment a bit more, is statutory damages, attorney's fees, and court costs. But like I said, we'll talk about that in a moment. So how do you actually register your copyright? Well, you complete an application form. You deposit or provide copies of the work that you're wanting to be registered, and you pay the applicable fee. So you can actually do this online at www.copyright.gov. And while you don't have to be an attorney to apply, you may want to consult an attorney or hire an attorney because mistakes in the application can result in delays and even rejection. So that's registration. That's one way you can protect your copyright. Another way you can protect your copyright is through a copyright notice. And on the screen, I've got an example of what a copyright notice might look like. So it must include three elements. It has to include the symbol, so that C with a circle around it, or it could include the term copyright instead of the symbol. The second element is that it's got to include the name of the owner. And the third is that it includes the year of first publication. Now, importantly, you don't have to have registered the work to include a copyright notice. So if you snap a picture today, even without registering that, you can include a copyright notice on that photograph. And what are the benefits in doing that? Well, there's really two key benefits. One, kind of like registration, this puts people on notice that the work is owned by a specific person or entity. And second, it helps eliminate what's called the innocent infringer claim or an innocent infringer defense. Damages for an innocent infringer can be significantly less. So by sticking a copyright notice, you can help eliminate the argument that that person did not know that they were infringing. One thing I'm going to briefly mention here, and I'll talk about more in a moment, is the Digital Millennium Copyright Act, or the DMCA. So for those of you who are not familiar, the DMCA is a federal law. It was enacted to address certain copyright issues related to online content. One thing I want to mention here is that the DMCA actually prohibits the distribution of false copyright management information or the removal or alteration of copyright management information. And what's copyright management information? It's the work's title. It's identifying information about the author. It's identifying numbers or symbols. So for example, if you remove or alter, let's say copyright 2018 John Smith from a photo, this can actually be a violation of the DMCA if it was done intentionally or knowingly. So registration, copyright notice. The third way you can help protect your copyright is through agreements. So if you choose to share your rights with another, if you choose to license your work, understand what rights you are actually granting. For instance, does the licensee only have the right to use the work for a particular purpose? So I mentioned copyright infringement. What is copyright infringement? Well, copyright infringement is the violation of one or more of the copyright owner's exclusive rights. Those rights like to reproduce the work, display the work, etc. A copyright infringement case requires proof that you owned a valid exclusive copyright and that the defendants infringed that right. The person he would be suing infringed your exclusive rights. Basically, what does that mean? It's using a work without permission. That's what copyright infringement is. Now, I want to bring up something here where I think there is some confusion. Just because you give proper attribution to something to avoid plagiarism does not mean you're not infringing the work. So let's say you find a photograph online and you copy and you paste it to your website. Let's say you find a photo that you like and you put it on your website. But to try to avoid any indication or view of plagiarism, you include some text and you say, well, the source was ABC Photography. Unless ABC Photography has given you permission to post that photo on your website, either by specifically entering into agreement with you, in a traditional stack of paper signature agreement, or through their terms of use on their website or a pop-up agreement on their website, this can actually be considered copyright infringement. Now, not to confuse the point, if I haven't already made this confusing, don't get this issue confused with IDX, where all you might need is attribution. With IDX, brokers may display listings of other brokers with proper authorization. Depending on your MLS's IDX rules, consent to display listings on another broker's public website or on a mobile app controlled by another broker is either presumed or must be established in writing, usually within the MLS system. And most MLSs have established that consent is presumed. But outside of that context, again, just because you stick an attribution, hey, I got this photo from this site, doesn't mean you're okay. It could still be copyright infringement. So what are the remedies? So let's say you sue someone for copyright infringement, for using your work without permission, or you are sued for copyright infringement. What might happen? Well, first, injunctive relief. Basically, a court could issue an order to stop that person from infringing. So it's a court order to stop you from infringing or using that work without permission. The second thing that could happen would be an award of damages. So under copyright law, there's two options when you are suing someone for infringement. You can try to pursue actual damages and wrongful profits, or statutory damages. Now, I'll get to what statutory damages are in a second, but actual damages have to be proven in court and can be more difficult to establish. So that's one option. The second option is statutory damages. And they're called statutory damages because the range of damages is actually established by that copyright statute. Now, you may be asking, why would I ever choose actual damages and wrongful profits over statutory damages if it's harder to prove actual damages? Well, there might be a couple of reasons. The actual damages and wrongful profits could be more than the statutory damages. Or the second reason is you do not have a prior registration. So let's get into that a little bit more. You can only receive statutory damages if there is a prior copyright registration. So remember, we talked about the benefits of registration. This is one of them. This means that the registration has to either be made before the infringement happens or within 3 months after the first publication of the work. And publication generally is the date copies of the work are first made available to the public. So let's break that down a little bit more. What are some examples? So let's say you publish a work in January and you register that work with the Copyright Office in June, but there's infringement that happens in July. You, in that situation, can still be entitled to statutory damages because registration was made prior to the infringement. Let's tweak the facts a little bit. You publish a work on January 1st. The infringement happens on February 1st, and you register your work a few days later, February 15th. In this situation, you can still be entitled to statutory damages because the registration was made within 3 months after publication. Now, typically, statutory damages range between $750 and $30,000 per work. This is determined by a court, so the range is pretty wide there. Now, if the infringement or that use without permission was willful or intentional, damages of up to $150,000 per work can be assessed by a court. I talked about innocent infringement earlier. If the infringement is innocent, meaning they didn't know or had no reason to believe that they were infringing, damages no less than $200 per work can accrue. So that's why including a copyright notice is so important. Now, statutory damages apply per work, not per infringement. So if multiple works are infringed, there can be multiple awards of damages. So example, let's say that 5 photographs were used without permission. 5 photographs were infringed. The court decides to award damages of $1,000 per work. So that's $5,000 total. It's not per infringement, it's per work. The last remedy there that I want to talk about is attorney's fees and court costs. So like statutory damages, attorney's fees and costs cannot even be awarded to the copyright owner unless there is a prior registration. So again, prior registration means the work was registered before the infringement occurred or within 3 months after the work is published. Okay, so what about fair use? We sometimes hear people say that they're okay copying or using someone else's work in their work because it's quote-unquote fair use. Well, fair use means that the material is being used without the permission of the owner for a new purpose, for what's called a transformative purpose. Now, fair use is an affirmative defense, which means you're not making this argument until you've been sued. It essentially is saying that even if the copyright owner is right, that you are using that work without permission, you may still be able to avoid liability. And you typically see the fair use argument applied to a criticism or a parody of someone else's work. Now, in determining whether any use is fair use, a judge or jury will consider all of the following factors. So the first factor a court would consider is purpose and character of the use. So the less commercial and more transformative the work, the better. And again, transformative means it's adding something new to change the character or the purpose, to alter that first work. So that's the first factor. The second factor is nature of the copyrighted work. Was the work factual or creative? Was it published or unpublished? So fictional works, for example, typically get more copyright protection than a nonfiction work. The third factor there is how much was taken. The more is taken, the less likely it's considered fair use. The less that's taken, the more likely it could be considered fair use. And then finally, economic impact. How does this impact the copyright owner's market? The more the use decreases the value of the work, the less likely it's going to be considered fair use. So a court is going to review all of these factors, particularly the effect on the market and whether the work was transformative. What's the bottom line for you? You really should not rely on fair use because you're really not even making that argument until you've already been sued, and that's not a place you want to be. So how does any of this impact me or my brokerage? That's the important part of this presentation. How does this impact you or your brokerage? Well, typically this is going to impact you through use of photographs when marketing the property. This is not the only way, but this I think is going to be the most typical way. So what are some examples of how this might come into play? How copyright might impact you? Well, first, in this scenario, so let's say a seller or a photographer provides a photo to an agent or broker, or an agent provides a photo to a broker. That can be one situation in which copyright issues can impact you or your brokerage. Another scenario, the agent or broker uploads a photo to the MLS or submits to a portal or vendor, who in turn may allow the photo to be used by other agents and brokers. So in both of these examples, it's important to ensure that the person granting the rights actually can do that and has the rights that match the intended use. So let's go back to the photographer situation. If there is one break in the chain, someone doesn't have the rights they say they do, this can impact everyone who uses the content. So let's say the seller shares or provides a photo to an agent or a broker, but the seller never had the ability or the right to do that in the first place. Well, not only can this impact the agent and the broker, if the agent and the broker are uploading that photo to the MLS or to other portals or vendors, that can impact everyone. So again, if there's one break in that chain, someone doesn't have the rights they say they do, this can impact everyone. Luckily, TAR has some resources that we'll talk about later to assist you in securing the necessary rights. So let's go through some relevant case law, because it's one thing to talk about this generally. I think it's helpful to see what's actually happening out there. So the first case I want to talk about is Adams versus Agrusa. And this is actually a California case, but a California court basically affirmed the judgment that a California sales agent infringed another brokerage's copyright by using photographs of a property in the MLS. So what are the facts here? Well, the brokerage entered a property into the MLS with 20 copyrighted photos, meaning the brokerage owned and had registered those photos. And the brokerage went a step further. They included the copyright symbol on each of those photos. So the brokerage was doing what they needed to do to protect their copyright. That seller terminated the listing agreement and entered into a new listing agreement with a different brokerage. Now, someone at that new brokerage downloaded those same photos from the MLS, actually removed the copyright symbol, and then gave the photos to the sales agent, telling her to use them in the MLS listing. That previous brokerage filed a lawsuit alleging copyright infringement. So again, kind of reviewing what we talked about, if a court finds that there is infringement, that court has discretion in awarding damages, with statutory damages ranging from $750 to $30,000 per work. However, if the infringement was innocent, the court may award damages as low as $200. So in this case, the court actually ruled that the sales agent was an innocent infringer because someone before her had taken or removed the copyright symbol from the photos, and so there was no evidence that the sales agent knew about the copyright. So the court actually awarded the brokerage only $250 in that situation. But this case is important because you don't want to be in the position where you're being sued in the first place. So it's important that everyone at the brokerage understand these issues, what you can and cannot do, whether you can use those photos, whether you can take the copyright symbols off of the photos. The second case I want to talk about is Prestonwood versus Urban Living. So Prestonwood is an architectural design firm. Urban Living is a real estate development firm. We've talked mostly about photos, but architectural drawings can have copyright protection, just like photos. So Prestonwood and Urban Living entered into a license agreement to use architectural drawings. After that point, Prestonwood alleged that Urban Living was using the drawings without permission and had actually removed Prestonwood's copyright management information. Again, that could be Prestonwood's name, it could be identifying information, copyright symbol, that kind of thing. Prestonwood sued Urban Living, and a jury found that Urban Living had violated the DMCA. Again, remember, that's the Digital Millennium Copyright Act, by removing that copyright management information 11,516 times. So a judge ordered Urban Living to pay $28.8 million to Prestonwood. So I don't say that to scare you, but I think both of these cases illustrate the point that it's important to know about these issues because they can impact you. They can impact your brokerage. So how can I protect myself or my brokerage from a copyright infringement claim? Well, the first way you can really protect yourself or your brokerage is by knowing your rights. Don't use content like a photograph or other listing content unless you have permission. Remember, this includes taking things from the internet. You know, don't do a Google search for an image, copy and paste that image to your website or use it in other ways without permission. Review your existing agreements so that you know what rights you have, and make sure your use complies. Remember, existing agreements can even be website terms of use or website pop-up. And then finally, ensure future agreements have given you the necessary rights. And we'll talk about ways that you can help ensure that in a moment when we get to some of the TAR resources. The second way you can help protect yourself or your brokerage is through the Digital Millennium Copyright Act, that DMCA, its safe harbor provision. Now, before I get into the details of this, I do want to point out that TAR does have a model DMCA safe harbor policy that's free for our members' use. It's currently on our website, again, texasrealestate.com, under the legal tab and then manuals and guides. So don't get worried if you can't memorize everything I'm about to talk about. We do have a model policy on this topic. So again, the DMCA, that safe harbor provision, can help protect you from a third party's infringing activity as long as you comply with the requirements. So just some background here. Again, the DMCA was put into law to address copyright issues related to online content. And it provides what's called online service providers a safe harbor or liability protection from copyright infringement in certain circumstances. An online service provider could include you, a real estate brokerage, any broker or agent who provide or host websites, including websites or portals that allow consumers to search real estate listings or other real estate information online, or websites that provide other online services. So this can impact you. You can be considered an online service provider. Now, prior to the DMCA, an online service provider could be held liable for material posted or stored on its website, even if the material was posted by a third party. And given the nature of websites, of our websites in particular, it would be very difficult for the brokerage or the agent or the broker to screen every post or submission for every user. Therefore, it would be easy to host or have copyrighted material on your website. So what's an example? Your brokerage may display listing content of other brokerages on their public-facing websites via an IDX feed. So it would be difficult to screen every post to make sure it's not infringing in that situation. As long as that online service provider meets certain requirements, the online service provider is protected from liability for infringement when users, not the online service provider, post or submit infringing content on the website. But again, there are some specific requirements. So in order to ensure you have this safe harbor, the online service provider must not have actual or apparent knowledge that the material is infringing. The service provider, if it has the right and ability to control the infringing activity, must not receive a financial benefit that can be directly attributed to the activity. And upon receiving notice of claimed infringement, called a takedown notice, the online service provider has to work quickly to remove or disable access to it. In addition to those requirements, you have to have it designated an agent with the Copyright Office to receive takedown notices, and you've had to have paid the applicable fees. And you can do that by going to the following website, dmca.copyright.gov. Again, all of this is outlined in that model policy that I just mentioned. You have to include contact information for that designated agent on your website, including the name, address, phone number, and email address of the agent, as well as the full legal name, physical street address, and alternate names of the online service provider. And finally, the online service provider must adopt, implement, and inform users of a policy that provides for termination of repeat infringers. Now, again, as I mentioned, we've got that model policy. You can use that with your brokerage to help ensure that you are complying with that safe harbor provision. So I've been talking about TAR resources. We mentioned how can you protect yourself or your brokerage from an infringement claim. Well, how can TAR help you? TAR has actually created some model forms to help address some of these issues we've been talking about, specifically to help ensure that you get the rights necessary to help protect you, to help protect your brokerage. These forms I'm going to talk about are all free, and they are not yet posted on our website. They should be either by today or at the very latest by the end of the week. So if you don't see them today, check back Thursday, Friday. They will be posted on the same page with our other model policies. Again, go to our website, texasrealestate.com. Under the legal tab, go to manuals and guides. That's where you'll be able to find these items. Now, all of these forms that I'm going to talk about are designed to work together and also separately, meaning that if you want to use all of these, you can. If you just want to use one, you can. It's up to you. These are all optional, of course. They're model policies, and they're really designed to address the bare minimum. So, it's very likely that depending on the circumstances of your brokerage, you may have to go in and modify or add things. But this addresses at least the bare minimum. So let's talk about the first one, the model addendum to an independent contractor agreement regarding listing content. So this is a model addendum to be used with an independent contractor agreement. It's designed to address ownership issues between the broker and the agent, ownership issues of listing content created by an agent and third parties. And really the purpose is to grant the broker the rights necessary for the broker to use the listing content. So as an example, the broker has to have appropriate rights to list property in the MLS and allow the MLS to make IDX listings available to others, other brokers, for example. And so without something like this, without language like this, the broker is going to be unable to properly grant the rights to the MLS. So let's go through the model form in a little more detail. Again, screenshots of what the actual forms look like. Again, hopefully these will be posted soon. So let's kind of go through this paragraph by paragraph so you have an idea of what all of this means. So starting with paragraph 1, pretty simple, those are definitions that will be used throughout the form. Section 2 here, ownership and use of associate listing content, deals with listing content created by an associate. And this section provides 2 options. And by the way, when I say associate, I'm talking generally about the agent. So the section provides 2 options. The first, which you can see here, box A, is the broker and the agent can agree that any listing content the agent creates is a work made for hire. And I talked about that belt and suspenders approach earlier. The work made for hire box also follows with assignment language and license language if the work made for hire agreement were to fail. Let's go to the second page. The second option here is a license. So it's a non-exclusive license where the agent could retain ownership but agrees to grant the broker the necessary rights for broker to use the listing content. Section 3 here, get a little closer, representation. So this is a section where the agent is stating that yes, the agent did in fact create the listing content and that they're not infringing anyone else's rights by granting the broker these rights. So this is important to note, because if these statements are not true, the agent could be held in breach or default of the independent contractor agreement. And then the last section there, section 4, deals with ownership use of third-party listing content. So this section requires the agent, when working with a third party, to use certain types of agreements selected by the broker, a work made for hire, an assignment, or a license agreement. And it also requires the agent to submit any contracts to the broker for approval. So if the broker says, you know, hey, if you're going to be working with a third party, like a photographer, make sure that you get a license agreement or an assignment. Or make sure you get all 3, make sure you get one of all 3 of these. So the broker could check the work made for hire, the assignment, and the license agreement, and the associate would be able to get one of those to comply with this section. So again, kind of up to the broker, the agent, to work that out, to have that discussion. So that's the model addendum that could be used with an independent contractor agreement. What's next? A model copyright policy. So this addresses ownership of listing content, again, created by agents and third parties, and it instructs agents on how to properly use listing content and the types of agreements they must secure. So this is actually pretty similar to the addendum, but it also addresses how the agent should use listing content, basically in compliance with the law and compliance with agreements, and provides instructions as to how that agent should handle a notice of infringement. So here's what the model policy looks like. You'll notice it's pretty similar to the layout of the addendum. You've got your definition section. You've got ownership of listing content if the associate is creating listing content or if the associate is working with a third party. and the types of agreements that the broker might require. In Section 3, you've got approval required, that prior to entering into any agreement with a third party, the associate has to get approval from the broker. The fourth section here deals with use of listing content. You know, you've got to use, or you can only use listing content in compliance with the law, in compliance with agreements. There's also the notice of infringement section. If you receive a notice of infringement, agent or associate, you have to notify the broker immediately. So again, similar to the addendum, but this was a policy in place. So you could use both of them at the same time. You can use them both together. You could use one or the other. It's up to you. And then finally, we have model photography agreements. So we've created 3 model photography agreements, and these are designed to be used by a broker and a photographer when a photographer agrees to photograph a property. So there are 3 agreements here. The first is a work made for hire. And a work made for hire, again, is where the broker is that automatic owner, that author and owner of the photographs from their creation. So you've got this language here. And you'll notice, again, as I mentioned, these are pretty bare bones. So it's possible that this doesn't address everything you want to address or that the photographer wants to address, but at least you have a starting point. The second model agreement is an assignment agreement. The photographer agrees to assign all rights or is assigning all rights to the photographs to the broker. And then the last is a model license agreement. The photographer will retain ownership of the photographs but grants the broker a license to use the photographs. So one important thing I want to note here is that sometimes, perhaps often, photographers have their own agreements, or they will simply refuse to use yours. And we'll get to some steps that local associations are taking to address that in a moment. But at the very least, you can at least use these as a guide to be better informed about what rights you may need. So what are some other resources that, in addition to the TAR resources, that you could utilize? So the other resources are, for instance, the TAR residential and farm and ranch listing agreements. Both of those, or all of those agreements rather, contain language where the seller is granting the broker a license to be able to use listing content created by the seller. So that's important in securing those rights. Remember, think back to those diagrams. Important to make sure that the seller is giving you the rights necessary that you need. So that can be addressed or is addressed in the listing agreement. Second, another resource is both the U.S. Copyright Office and NAR actually have a wealth of materials on copyright law. So if you want to dive a little deeper into this, both of those places are great options as well. And then finally, your local association or MLS may have resources. So for instance, we do know that there are some MLSs who work with photographers who agree to license their photos to the MLS, so that if members don't have to worry, they can easily use the photographer's photos and marketing materials for the property and on social media. So it's possible your MLS or your local association has tried to address that issue of photographers not wanting to use your license agreement, or they only want to use their license agreement, which may not give you the rights that you need. So all of these resources can help protect you and your brokerage from copyright infringement. Now, as I mentioned, again, these forms are not yet, at least the TAR resources, are not yet available, but I did want to just show you where you can access those once they are. So once you go to our website, you can go to Legal and Ethics, and then Manuals and Guides. And this, of course, is where you can find that DMCA Safe Harbor model policy, but this is where you'll also be able to find those model forms. So that concludes what I had planned for remarks today. Let's get to questions. So if you have questions, go ahead and type those in. So I do have a question, whether you will be able to review the webinar afterwards. Yes, the slides for this webinar are actually available now on the events page of our website, which is texasrealestate.com. You can download the slides, and then we are recording this webinar, so you'll be able to find the link to the recording on that same events page. We'll also include a link to the recording in the follow-up email you'll receive after the end of today's webinar. You usually receive that about an hour after the webinar has concluded. Okay, I do have a question here. How is an assignment different from a work made for hire? So that's a good question. So an assignment is different in the sense that a work made for hire means that the hiring party always owned the work. So let's think about the employer-employee scenario. If the employee is creating something within their job description, I mean within the course and scope of their job, then it's the employer who actually owns the work, and they own that from the moment it's created. With an assignment, that ownership has transferred. So the author who originally created the work owns it, but then transfers that ownership later. So that's the biggest difference. You know, is one better than the other? There are some benefits, which is why you see a work made for hire sometimes being the preference, even if it doesn't necessarily work because it's not within one of those 9 specific categories. But the length of copyright protection can be longer with a work made for hire. An assignment actually can be terminated in certain circumstances after a period of time. It's around 35 years, I believe. So there can be benefits in choosing a work made for hire if you can get it. But again, like I said, you can't always get that protection, that work made for hire. And so that's why you'll often see assignment language side by side as that belt and suspenders approach. Okay, I've got another question here. Can I copyright my website? Yes, you can. So you can copyright your website. You can copyright those original works, those original works that have that minimal degree of creativity. So that would include, you know, photographs on your website, you know, writings, artwork, things that you created on your website that possess that minimal degree of creativity. Again, there's procedures for that, and the Copyright Office provides some helpful information on that. If you do want to copyright your website, again, you can always consult a private attorney who can help you address that issue. Okay. So next question here, public domain. What does in the public domain mean? So the term public domain actually refers to materials that aren't actually protected by intellectual property laws like copyright. If a work is in the public domain, that means anyone can use that work without obtaining permission. So how do works get into the public domain? Well, sometimes if the copyright has expired, they can be in the public domain. If the copyright owner specifically said this is the public domain, dedicated it to the public domain, it can qualify as that. If copyright law doesn't protect that type of work, let's say it's a fact, which, as we talked about earlier, doesn't have copyright protection, then that could be something in the public domain. Okay, next question. Okay, so here's a question. If I work with a photographer to take photos and they say that I can have ownership of the photos, but the agreement doesn't say anything about that, do you actually have ownership? The answer is no. With an assignment under copyright law, if it's an assignment or if it's a work made for hire, maybe they're saying, you know, hey, this is going to qualify as a work made for hire. Either way, that has to be in writing and that has to be signed. So regardless of whether the photographer is saying, yes, you own this, these are yours, it's got to be in writing for that to be effective. Okay, I've got a question here. Does copyright protect architecture? And this will probably be the last question we can take, just so we can end on time. So yes, we talked about that case earlier, where the Preston Wood, that architectural design firm, had licensed their drawings to Urban Living. So yes, architectural drawings, architectural works can have copyright protection. There is some quirks in the law or some changes in the law where after a certain period of time, architectural works were protected, but prior to that time they weren't. And I believe that's 1990. So that copyright protection would extend to architectural work created on or after, I think it's December 1990. But yes, architectural works can have protection. Okay, well, thank you everyone for joining us. I hope that you learned something today. Again, the slides are available now. The recordings will be available soon, so if you missed anything you want to go back and review, you'll have that ability. And certainly if you have any questions, you can always give us a call on the legal hotline. That is 512-480-8200. All right, thanks everyone. Until next time.